My name is David Burns. I'm one of the partners here in the Litigation department at Ronald Fletcher Baker Solicitors. I wanted to do a brief video today about commercial rent arrears. This is an issue which we see consistently crop up, and it's worth going through some of the options that are available to landlords in these circumstances. We've recently acted for a tenant who had accrued rent arrears of in excess of £2 million. We act on behalf of several landlords where the rent arrears have exceeded several £100,000, and there also are several cases where rent arrears of say a few £1,000s still need to be addressed and dealt with. So obviously each case will turn on its own facts, and the terms of the lease will need to be considered, but there are some general options that are potentially available to landlords in these circumstances which are worth flagging. So one option available for landlords in these circumstances is to exercise its right to commercial rent arrears recovery. That's where a landlord will serve prescribed notices on a tenant and attend the property, or bailiffs will attend the property and take control of goods and sell those goods up to the equivalent value of the rent arrears that have accrued. Obviously that option is going to be suitable where there are goods of sufficient value which are in the property. Another option is to issue a claim against the tenant. So usually in those circumstances, we would first serve a letter before action on the tenant demanding the rent, and usually the legal costs have accrued, because there's often a clause in the lease which permits the landlord to recover its legal costs arising from enforcing the breaches in the terms of the lease. If the tenant fails to pay following the demand, then we would generally issue a claim against the tenant for those arrears. Another option to consider is pursuing a guarantor if there is one in the lease, or if the lease has been assigned potentially a former tenant. And that's something you would need to check whether either of those options are available in your circumstances. Another option which may be available is to draw down a rent deposit, if possible. Another option that's potentially available is to serve a statutory demand on the tenant. There is a risk, however, with taking that route, because if there is a genuine dispute in relation to the arrears that are owed, then the tenant may apply to set aside that statutory demand. And so it's important that you seek legal advice, certainly in relation to any of these options, but in particular if you are going to pursue the more aggressive approach of serving a statutory demand. Another option which is available, and we see landlords using quite regularly, is to forfeit the lease. Now, generally, leases will have a provision in them which permits a landlord to re-enter a premises if rent arrears are outstanding for a prescribed period of time, usually 14 to 21 days. And if that period is passed, then in certain circumstances the landlord is entitled to re-enter the premises. But one thing to flag for the purposes of this video is that landlords need to be careful that they haven't inadvertently waived the right to forfeit, because if the landlord then forfeits a lease in those circumstances, it could amount to an unlawful forfeiture, and they will be liable to the tenant for the damages that the tenant has suffered as a result of that unlawful forfeiture. If you do need assistance in dealing with commercial rent arrears, then we'd be more than happy to assist.